Okay, picture this. You're getting ready to head out to the polls, and literally 2 days before a federal election, the whole thing just stops. Welcome to This Explainer. Today, we are unpacking a truly unprecedented administrative intervention, one that didn't just freeze an active primary in Louisiana, but actually reshaped the entire national electoral map. We're going to unravel a story where high-stakes constitutional law collides directly with state-level emergency powers and some major demographic shifts. Let's dive in. We're talking about April 30th, 2026. Governor Jeff Landry basically hit the emergency stop button on all U.S. House primary elections across the state. And the wildest part of all of this happened a mere 48 hours before early voting was officially scheduled to kick off. I mean, imagine the sheer logistical momentum of a federal election being brought to a screeching halt just 2 days out. It was a massive shockwave.
So you really have to wonder, right? How exactly does a state justify pulling the plug on an active federal democratic process at the absolute 11th hour? Well, to figure that out, we have to look at this massive collision between a landmark Supreme Court ruling, decades of civil rights jurisprudence, and the raw political calculations that drive mid-decade redistricting. Here is the roadmap for This Explainer. 1. An election suspended. 2. How did we get here? 3. The Supreme Court ruling. 4. The immediate legal chaos. And 5. A national ripple effect.
All right, let's jump straight into Section 1, an election suspended. Using an emergency state statute, the governor hit the brakes. But here's the kicker. He only stopped the 6 U.S. House races. He left the rest of the May 16th ballot completely intact. So the primary for a U.S. Senate seat, the state Supreme Court, and the Public Service Commission, those were all still moving forward. The Secretary of State called the whole thing an electoral emergency. They argued that if they actually went ahead and held an election under a map that had been invalidated, it would just completely undermine voters' rights and invite endless lawsuits. Moving on to Section 2. How did we get here? To really understand this, we have to rewind to the 2020 census. The data showed that African Americans make up about a third, 33% of Louisiana's total population. But then, the initial congressional map drawn by the state legislature back in 2021 gave them just one majority black district out of the 6 available seats. That is barely 16%. You can see how that undeniable mathematical disconnect instantly became ground zero for a massive Voting Rights Act challenge. And it has been a seriously turbulent few years since then. After that initial 2021 map dropped, a district court judge found that it likely violated the Voting Rights Act and officially ordered a second majority black district in 2022. After a ton of pressure, the legislature finally drew one up in 2024. But almost immediately, non-African American voters challenged it, claiming the new map's pretty meandering shape was an unjustified use of race. That direct clash of constitutional priorities sent the case rocketing straight up to the Supreme Court. Which brings us to Section 3. The Supreme Court ruling. So the Supreme Court steps in and hands down a 6-3 decision. And the ideological divide here is super clear. Basically, the majority ruled that you cannot use race as the main factor in drawing lines without hard proof of intentional discrimination. They're saying states aren't forced to create a second minority district if their map already meets traditional districting rules. That essentially allows legislatures to cite partisan strategy as their defense rather than race. On the flip side, the dissent came out swinging. They argued this new standard is pretty much impossible to prove, and that it effectively guts minority voter protections under the Voting Rights Act by letting partisanship act as a shield for racially disparate outcomes. If you want a glimpse into where this whole thing might be heading next for the rest of the country, take a look at Justice Clarence Thomas's concurring opinion. He explicitly signaled a desire to just abandon using racial data in redistricting entirely. He completely rejected the idea that any legal framework should grant racial groups an entitlement to roughly proportional representation, and instead pushed for a strictly colorblind constitutional standard. Make no mistake, this points to a massive shift at the highest level of the judiciary that could completely redefine maps nationwide. All right, Section 4, the immediate legal chaos. And man, theory met reality practically overnight. Because only the House primaries were paused, it created an absolute logistical nightmare on the ground. Think about this. Over 100,000 mail-in ballots were already sent out, with those House races printed right on them. Now election workers have to basically tell voters, hey, your Senate choices count, but your House votes, we're just going to ignore those. Imagine the anxiety this causes for elderly voters or military personnel stationed overseas whose ballots were suddenly compromised after they had already cast them. As you can probably guess, massive lawsuits dropped almost immediately. Opponents are arguing that the governor unilaterally bypassed the U.S. Constitution's elections clause, which, gives election regulation power to the legislature, not the executive branch. They're also claiming that treating identically situated voters differently on the exact same physical ballot is a clear violation of equal protection. And crucially, they are leaning hard on what's called the Purcell principle. It's a legal standard that basically says don't change election rules right before voting day because it causes exactly this kind of mass confusion.
And finally, Section 5, a national ripple effect.
Because what happens in Louisiana is absolutely not staying in Louisiana. The ripple effect here is huge. In Louisiana alone, Republicans see an opening to regain up to 2 seats. Meanwhile, Mississippi didn't wait around. They quickly called a special session to leverage this exact Supreme Court precedent to aggressively redraw their own maps mid-decade. And we're seeing similar projected shifts in Florida and Alabama too, with state officials explicitly pointing to this new ruling to eliminate districts they are now arguing are unconstitutionally race-based.
The sheer scale of this is staggering. We are talking about estimates suggesting up to 20 minority-held seats nationally could be impacted. Civil rights groups are mourning this ruling, calling it a day of shame, that they say could roll back Black representation in Congress to levels we haven't seen since the 1990s. But we have to remember the broader context here. Even as these redistricting maneuvers are happening, huge external pressures, like voter frustration over the domestic economy or international military involvement, those are all still massive wildcards for the 2026 midterms. High turnout driven by national issues could definitely still disrupt these newly drawn maps.
Meanwhile, back on the ground in Louisiana, the pressure is literally off the charts. The legislature is staring down a ticking clock. They have roughly 60 days to engineer a completely new congressional map, one that satisfies this incredibly strict new federal standard laid out by the Supreme Court, but without provoking massive voter disenfranchisement or immediately running afoul of the federal courts again. It is an incredibly delicate tightrope to walk. So as we watch mid-decade redistricting potentially become this massive new tool of political warfare, it really leaves us with one incredibly critical question to ponder. With the highest court in the land demanding a nearly impossible burden of proof for racial discrimination, and states moving at lightning speed to redraw their maps mid-cycle, is the era of affirmative redistricting officially over?